a short talk, I assure you. And I think very fast moving and hopefully kind of fun. We're talking about celebrities in games. And there is a little bit of law here, but it's mostly about looking at all kinds of crazy situations and how the courts have come out in the US. And I have to say, it's a little bit unpredictable. So if you are here looking for some legal guidance and some clear rules, it may be disappointing. But let's just, in this quick 10 minutes, take a look at what's gone on in this area, at least in the United States. So basically, should come as no surprise to anyone. If you're a celebrity, you know, there's value attributed to your name, to your likeness, to your voice, to whatever little tagline that is associated with you. And you know, if we as game developers decide to utilize that value, then there's an expectation that we have to pay for it. And if we don't pay for it, then we could have the full wrath of a legion of Hollywood lawyers coming after us. There's a couple of bases on which celebrities can claim against game developers. One is the basic right of publicity, which we'll talk more about. And then there's a sort of trademark type of cause of action, false endorsement, where basically the individual, the celebrity's image is their trademark, and you have to license that from them. And if you don't, then there's certain trademark legal remedies. So we'll look at a number of cases here, and just basically, these are chronological. And you know, as you'll see, it would be nice if we could say, okay, here's 3 tests. There actually are 3 tests that are used by different courts in the United States in deciding whether or not the developer or the content producer, you know, could use the celebrity image. But as it turns out, those 3 tests have just been sort of randomly applied and mixed up, and so it's hard to kind of develop any coherence. So I just put these in chronological order. Maybe you'll see some sort of trend. 1983, this is probably the first sort of significant case of its kind in the US. Here's Johnny, of course, Johnny Carson, and someone decided, I mean, small company, the middle of the country, decided that would be good to use on their portable toilets. Sorry, we'll go back. And in fact, Johnny Carson won that case, and the Portable John service had to rename their service. I don't remember, I'm actually not aware what the damages were in that case. 1993, we had the Vanna White Samsung case, and maybe some of you remember this commercial where Samsung had created this sort of commercial from the future, or game show from the future. And Vanna White, of course, the very famous American actress in the 80s and 90s who used to turn the letters on the show, was depicted as a robot. And of course, Samsung would say, well, this isn't Vanna White, this is just a robot rendering of a kind of generic female celebrity figure who's turning the letters on the board. But the court felt like it was just close enough to her persona that Samsung had to pay her for the use of those valuable rights that she had built up in her image. $403,000. This is a crazy case. This is a jury trial in Missouri, again, sort of the middle of the country. And basically there's this hockey player, Tony Twistelli, who I think got his name because of his, you know, his aggressive, let's say, antics on the rink. This comic book author decides to name the mafioso character in his print comic book Tony Twist. There he is. And the jury finds $15 million of damages, which I'm sure is probably hundreds of times the actual revenue that was produced by that comic book. But, you know, scary. Just a word, so as I mentioned, there's 3 different tests that have been used by courts in the US. They try to make it sound fancy and like it will allow you to, you know, apply some predictability to the whole analysis, but in fact, it just hasn't been followed by the courts. But the first one, we'll just go in order from the plaintiff-friendly, which means the celebrity friendly down to the, we'll call game developer friendly. So the first test, which is most friendly to the celebrity, says, is the plaintiff's name or other personal information changed or transformed in a parody, or is the game just basically copying the plaintiff's personal information? Is there some kind of original creative content that's added? And we'll see a bit more how that's been applied. Transformative Work test takes that same analysis but applies it to the whole work. So in that case, you'd have, like, let's say it's a film, and let's say a certain celebrity appears for 10 seconds in the course of the 90-minute film. A court's more likely to say, relative to the work, this is actually pretty small, so we're not going to find liability. My assistant actually put this iconic poster from the Obama campaign in 2008, I think it was. Actually has nothing whatsoever to do with this, but I will briefly say this could have been a right of publicity claim by Barack Obama against the artist. And not surprisingly, the Obama campaign decided that they weren't going to pursue that. And in fact, as you may know, this image became a central kind of symbol of his campaign. In theory, he could have been entitled to some sort of royalties from that, which he did not claim. However, this artist, in fact, did wind up in court and wound up paying hundreds of thousands of dollars in damages because it turned out that the photo, as you may remember, was actually, the print was based on a photo from the Associated Press. So the third and final test that have been applied by courts, which is the most friendly to us as developers and content producers, the Relatedness Test, where the court just says, listen, you can use the celebrity's name, image, whatever you want, just so long as you're not kind of like making them endorse your product or something. As long as, the content of the work has like some kind of connection to them. Kirby, so this is, let's see, this is from 2006 versus the Space, this is, whoops. Yeah, Space Channel 5 is the name of her act, and this is Sega, case against Sega. And so as you can see, there's the actual person on the left, and there is the Sega rendering on the right. Court says, not close enough, no violation there. There's sufficient differences that made the character creative and transformative. In fact, this is not the best picture. There actually is a picture of her that looks a lot more like the Sega image. The EA Sports cases had a lot of attention recently, where essentially the athletes' statistics were used in the games, but not their names or actual, recognizable physical characteristics. $60 million settlement for the players. This case got a lot of publicity, Lindsay Lohan, and actually just in October, the court finally came down and said, in our opinion, sure, maybe there's some similarity there. I happen to think there's quite a lot of similarity, including the name that they used, Lacey Jonahs. But the New York court says, you know what, there's plenty of other stuff in this game. It's a parody. There's, it's obviously a work of fiction and satire, so we find no liability. And finally, we have this a case against case filed by Manuel Noriega, the, of course, infamous former dictator of Panama, whose image was just completely used without any sort of apology or modification in Call of Duty. They did not actually use his name, but it was obvious, unmistakably obvious, that this is who this was about. And to my mind, it's difficult to justify that under the cases that we've seen, under the existing legal principles, but somehow the court felt like, this is maybe some news value, and so there's even more reluctance to find liability because of the principles of free speech and special protection that's applied to individuals who are, involved in current events. The court said, this is again satire, parody, no creative additions, and we find no liability. Personally, I think it's just because Manuel Noriega is not popular with American courts. So anyway, probably hard to pull the conclusions from that in such a brief survey, but I think basically if there's one conclusion to take away, you just got to be careful. If there's a, you can put a clever name, you can modify, their facial characteristics or whatever, but if your purpose in using this celebrity in the first place was to, kind of ring a bell with your audience, with your players, the court's going to pick up on that. And it, as you can see from these cases, it's just not clear which way it could come out. So be careful. Thank you.